Professional. All right. All persons having business before the Honorable Associate Judges now presiding of the District of Columbia Court of Appeals. Draw near and give your attention. God save the United States and the Honorable Court. This Honorable Court is in session. Please be seated and come to order.
Morning, everyone. Welcome to the District of Columbia Court of Appeals. We have one case on this morning's calendar, a special sitting in Ransom versus United States, number 22 CM 692. Judge Deal unexpectedly was unable to attend in person, so he's participating remotely. And we will hear first from counsel for Mr. Ransom when you are ready to proceed.
Thank you, Your Honors. May it please the court, Jason Clark on behalf of appellant Omar Ransom, and I would request to reserve 3 minutes for a rebuttal. The trial court abused its discretion in this case by admitting six different 10-second clips without any evidence of where those clips came from, who made those clips, or how they came to be in the government's possession. And the trial court abused its discretion twofold, because not only did it not require authentication or any chain of custody, but in ruling on defense counsel's timely objections, the trial court failed to explain its reasonings or why it was overruling the objections. Thus, Mr. Ransom argues that the court abused its discretion with regards to those 6 different clips.
Can I ask you, is your argument that it's just impossible to authenticate video without having some evidence of who made the video, where it came from, what's happened to it between whenever it was originally created and then to the version that's being submitted into evidence? Or is your point narrower than that? And do you think that's possible, but it just wasn't adequately done here?
I think there are probably cases where it's possible. One of the fundamental issues with this case is that when the prosecution, the government did try and admit those videos, the questions that they asked the witness were, does this look like your lobby? The questions were not specific enough to actually go through and authenticate the video themselves. And so because
that was true of some. I thought with respect to Exhibit 7, they did ask a question about whether now the answers got more complicated, but they did ask the question about whether the video accurately depicted what happened. Or am I misrecalling?
So I believe that the thrust of the questions for exhibits 1 through 5 was whether or not that accurately depicted your hallway, or whether or not that accurately depicted your lobby. And I think it was that same question that was answered, at least through 1 through 5, for the witness. And all of those were admitted through the first witness, Miss Williams. And for each of those, that was the question that was asked. And then the court overruled the objection and admitted them. For some of those clips, there is then some further testimony, and there's some further back and forth about whether or not, or at one point, the witness, Miss Williams, is asked to describe what she is seeing in the clip. But this all comes after the court has already overruled the objection and already admitted the clips in.
Can I ask you the thrust of that point? Are you saying that in figuring out whether the judge's ruling admitting like exhibits 1 through 5 was an abuse of discretion, we should consider only the testimony of the witness up to the point of the ruling, and to the extent later questions and answers might bear on whether authentication would be adequate, we should be ignoring that? Is that your line? Is that your point? Or
I think that the court, well, that part of that issue goes to our second argument, that the court has abused its discretion because it failed to make a record. So I think that the court could have gone back and said, well, I initially admitted this in, maybe I was wrong about that and I should have, but then after hearing the rest of the testimony, it's clear that this witness had personal knowledge, that my earlier decision, now in reference to these further facts that came out, that was appropriate. I think the court could have definitely gone back and sort of cleaned up the record and done it in that manner. But because the court didn't go back and discuss any of that, then I think that this court has to assume that when the court ruled upon it, that issue, the court wasn't thinking about it. And in trying to determine whether they actually abused their discretion, I think you do have to sort of just look at the record as it was at that time.
Would you, oh, no, go ahead.
Sorry, Judge McLeese's question about Exhibit 7, I think is still pending, but with 1 through 5, didn't Miss Williams testify that that's what she was wearing on the day, and that's how she knows that it was the same day? Am I missing something?
She did it at least on Exhibit 1. So on Exhibit 1 is the one where you see them entering through the back door. And that is the one point where the trial court interjects and asks, well, wait, how do you know it's that date specifically? And she's testifying some 14 months and 20 days after those events. And she says, well, those were the clothes that I was wearing that night. And I think that as far as authentication goes, that's rather weak without any evidence about whether knowing how often she uses the back door, how often she wears those clothes, or anything else that was going on. And there's also.
And those might have been excellent questions for a defense attorney to ask, to say to the judge, no, wait a minute, I don't think that's adequate authentication. Before you rule on admissibility, I'd like to explore that a little further. But none of those questions were asked. So I get the point that there are lots of questions one might ask, but it seems like, at least in part, that might have been something that a defense attorney ought to have done to try to challenge authenticity.
Yes, certainly those questions could have been asked, but I would also say that question was only asked of, I believe, Exhibit 1, possibly one other exhibit of them in the hallway, and then it was dropped from that point on. But Exhibit 1 is not particularly a very important exhibit in the grand scheme of things. I think the most important exhibit in everything is Exhibit 7.
Yeah, I agree with you, counsel, but can you tell me what importance 1 through 5 have at all? I mean, don't 1 through 5 roughly align with the story that Mr. Ransom told? I mean, he agrees. Well, he doesn't dispute that there was an argument that she ran out of the apartment, does he?
No, he doesn't. In his testimony, he does essentially testify that he was there, that he entered. I guess what seems to be missing, or one of the other aspects of Exhibits 1 through 5, is sort of what's not contained in Exhibits 1 through 5, which is, according to Miss Williams, he kicks in the door. And so we do have the security camera looking down the hallway. And of course, there's no clips of Mr. Ransom coming into the apartment. There's no clip of Mr. Ransom going down the hallway.
That sounds like a rule of completeness objection, though, which you haven't raised. You didn't. If you had said in the trial court, look, we want to see the whole thing and we want to play the whole thing because it'll show something. Well, I think that would have been a successful request, but that request wasn't made.
No, and I think that
And relatedly, given that it wasn't in a way, I'm not quite sure why 1 through 5 in the form they came in is prejudicial relative to that point. In a way, that's an argument that they're exculpatory by omission, in that, the clips that the United States chose to put in don't contain corroboration of some important parts of the complainant's testimony. And that's a point defense counsel could have made that would have been, that's not a prejudicial aspect of them. That's a way you could turn that to your advantage as a defense counsel, I would think.
I think that's right. And maybe it's not so much the prejudicial effect of those clips is that they do seem to offer some corroboration to Ms. Williams' testimony at all.
Right, and I think Judge Deal's question is, to the extent that is corroboration that is consistent with your client's version of events too, if it corroborates both of them on points that no one was disputing, one could say, what's the marginal prejudice? So do you think there is anything in 1 through 5 that corroborates the complainant's testimony and is inconsistent with or runs beyond even your client's version of events?
In 1 through 5, I don't think that I could. That 1 through 5, there isn't a specific thing that I could point to that would be in contention with what my client ultimately testified to. I do think that there are actually certain things in 1 through 5 which are in opposition to what Ms. Williams testified to.
And that's helpful to you, it seems to me, rather than prejudicial to you.
That-
Can I-
that
can we step
is.
back for a second, though, because we haven't, there's a threshold legal question that we haven't discussed yet. I had understood you to argue in your brief that the trial court was obliged in determining whether these were adequately authenticated and admitting them to apply a clear and convincing evidence standard of the
Yes.
kind that has been applied to audio tapes in this jurisdiction. And the United States, I think, disputes that and argues that no, that's not the right standard. So what's your response to the United States' view that in light of, let's say, Johnson, for example, it's not really correct that the trial court ought to have been applying a clear and convincing evidence standard here rather than a reasonable probability standard?
I think that we are arguing that the Butler clear and convincing evidence standard should apply to these circumstances. Our response is that Butler itself was not a decision that was based upon either the physical medium, that being tape, or what was specifically caught on that tape. Butler was a case about recordings that were subject to some sort of adulteration. And the concern in Butler was that something may have been altered on the tape. And what Butler was dealing with, and why some of that language is about tape recordings, is because that's what the court was specifically dealing with in Butler. And also in the cases that it previously cited to was also tape recordings. But that's because Butler itself is an element of its times. I think Butler was in the 90s, and the cases that it primarily relies upon are cases in the 70s. And what we have from those times and earlier primarily are audio recordings. I mean, we had micro cassette recorders back in the day, but we didn't have ubiquitous.
But the defendant made the same argument in Johnson and we rejected it. And I mean, it seems like social media postings can be subject to adulteration or alteration in this day and age, just as much as, if not more than perhaps video recordings at least. So how do you distinguish the video recordings here from the social media postings in Johnson?
Because in Johnson, there was still additional evidence tying those recordings to the account. I think that part of the arguments that the defense was making in Johnson was, well, anyone may have uploaded this to my Instagram account, or somebody may have put that there, or I didn't make those videos. But at least in Johnson, you had the custodian of record come in and say, and they can testify that, these videos was uploaded on this date from this account, from somebody who had access to this email and with this phone number.
I mean,
And with
that seems to
those-
me a question of whether it meets the clear and convincing standard as opposed to what standard should apply in the first place.
I would say that at least in Johnson, and the individual who, and I don't recall if in Johnson, if those were supposedly, he personally made them himself, or if it was self videos or something like that. But the defense there would have been in a better position to at least say, I didn't make those, or could talk about that. Whereas here, Mr. Ransom faced with security video, and there's absolutely no evidence about where those videos went or how they came to be in the government's possession. At least in Johnson, we know they went to Instagram. Instagram held them for a certain amount of time. They predate the actual, events or charges in Johnson. But here, we don't know when these security videos were actually collected,
Right, and-
whether they were from that night.
One thing I was taking away from Judge Shanker's question, though, is are you suggesting that the way to read Johnson is sometimes a clear and convincing evidence standard applies to social media postings, sometimes it doesn't, or sometimes it might apply, sometimes it might not, and that will depend on the circumstances of how well authenticated the item in question is, because that seems a little circular or an odd test. You would think you'd want to have a line about when that requirement applies and when it doesn't, which line applies, which doctrine applies, which standard applies, you wouldn't think would turn on case specific circumstances of how well authenticated the document is.
I agree that, social media is a challenge for this court, in authentication, and the chain of custody issues going forward. It's going to be, and as technology changes and advances and there's more, just AI generated art and content out there, and it becomes easier and easier to make these things. I think that Johnson, at least, we know that Instagram doesn't allow just anyone to upload anything. And we know that in Johnson, the account was, or at least appeared to be authenticated to this individual. And so I think that that meets it. But, and here, the fundamental difference is we just don't know where these videos came from.
Is your position, sorry, is it your position that do you need the Butler standard to support your argument? Or would you also say that even under the Johnson standard, there was no reasonable probability sufficient for authentication here? I can't remember what you said in your brief, but
I believe in our brief, we took the position that even under the lesser standard, we would still say that there's no reasonable probability, because it's just not sufficiently tied in time or with the testimony from the witnesses. And I think that there is a difference between Exhibit 7 and Exhibit 1 through 5 in that regard. So I think that if we were to look at it in that lesser standard, we have a much harder argument with Exhibits 1 through 5, because at least in Exhibit 1 through 5, you have an individual who is saying that they're identifying themselves and that happened on that night. But in Exhibit 7, you don't have that. You don't have anyone testifying that that they personally were there. And I'm sorry.
Well,
You do have Sonia Pryor.
she just gets it wrong.
Well,
that
wrong
looks
about
like
every
it,
important
except-
aspect.
yeah. All right.
Yeah, she says she's present, but she doesn't appear in the video. We don't see her in the lobby.
Well, you're not suggesting that's essential. And it seemed like at the Exhibit 7 at the beginning seemed things were going pretty well for the United States originally, because they asked what seems like the more precise question, which is, does Exhibit 7 fairly and accurately represent what you recall happening on June 12th of 2021? That seems like it's if answered yes and not later contradicted, it seems like that would be an adequate way to authenticate a video with respect to what is happening on the video, if that's what you're trying to prove through the video. Do you disagree that if the answer to that question was yes and things hadn't taken a turn to get more complicated, Exhibit 7 would have been properly authenticated as against either standard?
If her answer had been yes, that's
Well,
what happened.
I mean, that is the first word she says. It's
Right.
just then immediately after she says, except no.
Except no on this important aspect, on this important aspect, on this important aspect. And that leaves you to wonder, well, okay, what was she agreeing to? Was she saying, yes, that does look like my lobby, except, I saw a totally different series of events occur in my lobby. And so I think that in order for the government to have sort of saved that, they need to go back and ask further questions or preserve it. But and fundamentally, again, with Ms. Pryor, you are in a position left thinking at the end of her testimony that she doesn't actually have any personal knowledge of what happened here, because she then blurts out that, well, she was saying he had a gun because she believed, or somebody else had told her that he had a gun. And so she believed that he had a gun when he was running through the lobby. And she also then says, well, it's tucked in his pants. But what we see through her testimony is that she's willing to essentially say anything to assist Ms. Williams' case, or what she believes will at least assist.
And the government did go, you were suggesting that it might have been a different case if after the problem initially arose with this witness, the United States had circled back around and tried to kind of patch things up. And I thought they did do that. Again, whether adequately is the issue, but they later, I thought, came back. This is on page, a little trouble here. But a couple pages later, they come back and they say, can you play it again? They play it again, and it says, did Exhibit 7 fairly and accurately represent what you remember happening on June 12th? And without a qualification, the witness says yes. So they did circle back around. Now, whether adequately, I understand, but to the extent you were suggesting they really didn't try to deal with the problem, they took at least that step. And that was before the trial court admitted.
And I would say even with that, there's still the court, or I don't think the trial court then explained their reasoning as to denying the defense's objection. And on that one, particularly, the defense made a very specific objection about the lack of prior or the lack of actual personal knowledge. And you don't see her anywhere in the clip. It doesn't appear that she would have been in position, and you can sort of look at it's clip number 10 with the body worn camera, where we see an individual who may or may not be Sonia Pryor go through the lobby and go up the elevator. And there's no, Mr. Ransom's not in there. It doesn't appear that that's happening at that point. And there's no one else in a position and where she could have been actually or seen what she described seeing in the lobby. And so looking at those two things together, you really can't say that she was there at all based upon her testimony. Because she also says that, this happens when Miss Williams comes running out through the double doors, and that she's standing in the area of the double doors when Mr. Ransom goes running through the lobby. And if you look at number 10, well, Miss Williams comes out the double doors. There's no Miss Pryor there. There's another woman who's talking around and then says something to Miss Williams, which I believe is, I'm going to go collect your child from upstairs. And they walk through the lobby and go up the elevator. And there's no Mr. Ransom. And it doesn't appear that there's anyone else who could possibly be Miss Pryor or have any way of actually viewing the things that they end up testifying to. And that is certainly in the evidence. It's not an issue that is explained by the court resolved by the court with any of the rulings. And I think it's also clear that in the end, the trial court.
And that's also, I don't think, so much a specific point that was made to the court by the defense attorney. It's not like the defense attorney said, oh, by the way, part of the reason I'm challenging the admissibility of Exhibit 7 is because if you look at Exhibit 10, which maybe hasn't even come into the scene yet, I forget the order in which things happened, but the number suggests maybe it cropped up later. I don't remember anybody saying to the trial court, you need to think through or be aware that Exhibit 10 is going to contradict this and supports my concern that this is really not rooted in personal knowledge. Is that the point that was ultimately made to the trial court, or is that not so much something that was raised at trial and instead is a point that you've developed on appeal?
Yeah, not so much. I don't think that that's a specific factual issue that was pointed out. I would just say that, but how many more times was the defense to object to these exhibits? The defense maintained their objection. They raised the specific issue of personal knowledge with regards to this one. It was batted down without explanation. So I'm not sure what else the court or defense counsel would do at that point.
All right, I was looking to non-existent Judge Deal here to see if you had any further questions, but unless my colleagues have further questions, we'll hear from your opponent. We'll give you 3 minutes in rebuttal.
Thank you.
May it please the court, Brian Hanley for the United States. In this case, the trial court did not abuse its discretion when it admitted government exhibits 1 through 5 and government exhibit 7. The United States presented the testimony of Ms. Marquita Williams and Sonia Pryor, who demonstrated a reasonable possibility that the evidence in question, which were these surveillance videos, were what they purported to be.
Why do you call them surveillance videos?
Yes.
What's the evidence that they were surveillance videos?
I'm sorry, Your Honor.
What was the evidence that they were surveillance videos?
Your Honor, when I say surveillance videos, I'm speaking regarding the, I guess, the position in which they are taken. They're up high, they're in hallways, above doorways. I guess from a common understanding, they appear to be.
Well, I mean, as they were introduced into evidence at trial, they're visual depictions that a witness said various things about the accuracy of. So I'm not entirely sure it's supported by the evidence that was submitted to the trial judge in connection with authentication or the actual evidence that was introduced to refer to it as surveillance video. That's sort of what it seems like. You know, if you were guessing what it was, you might call it that, but nobody introduced any evidence that it was even, I mean, it's a video depiction. We don't know how.
Yes, Your Honor.
We don't know it's a recording, for example. I mean, it seems probably was, common sense would tell you it might be, but there was no evidence it was a recording.
Yes, Your Honor. And I would agree that they are visual depictions. These were videos, clips that were offered into evidence. When I use surveillance, that's probably a reflection of facts that are not before the court in the record, that they were surveillance videos. But I would concede that they are visual depictions. It's silent video clips that were offered.
Can you, when you say a reasonable possibility that it is what it purports to be, do you mean that it is what the party seeking to admit it purports it to be? Or do you mean a reasonable possibility that a witness who has said it is that thing is telling the truth? Because those are two very different things.
Your Honor, the way I interpret the proponent, what the proponent is purporting it to be. We're offering these clips. The government is of a video footage of something taking place, for instance, on June 11th that night or June 12th later in the night. The witness who is testifying is able to provide that testimony that.
Yeah, but why do you even need a witness if the question is there a reasonable possibility it is what the government says? I mean, there's a reasonable possibility this is what happens when the government said, but no witness said anything like, yes, exhibit number 7 is what I saw that night. Who says that?
Your Honor, I would disagree that with regards to with each exhibit 1 through 5, while the statements of the prosecutors, I think, could have been more specific in the way they were asked, they could have included the phrase reasonable, fair and accurate representation of the events recalled, which are specific to what the videos are showing. As the court pointed out in exhibit 7, it does state it clearly, the events specific. But when you look at the context in which the questions are asked by the prosecutors, it does highlight that it is talking about the clips from that evening. It just did, for instance, with government exhibit 1, prior to that being offered, you have Ms. Williams.
I'm sorry, I could be breaking up and I apologize if I am. But I'm trying to focus in on exhibit number 7. Who said that's what happened? That's an accurate depiction or anything like it of what happened that night. You know, the only witness you've got says, yeah, except for the fact that he came off the elevator and not the stairs, and he had a gun and not a belt, which sounds like the opposite of authentication to me. It sounds like that's the same area, but that's a different thing than what I saw.
Understood, Your Honor. So with government exhibit 7, so Ms. Pryor testifies prior to the prosecutor even presenting government exhibit 7. She asks about the events from that evening. So she describes Mr. Ransom coming through the lobby in it is different than what is in the video. When she sees the video, I think there's some legitimate surprise on the record that my recollection of the way this happened does not line up with the video.
Yeah, I think that's 100% backwards. If the only way the video is being given any weight is because a witness is vouching for it. If it's a useless piece of, frames of pixels, unless the witness says, yeah, that's exactly what happened, then it seems entirely backwards. I mean, it'd be one thing if the witness said, now that I've seen this thing that I couldn't vouch for initially, the light bulb is going off in my head and now I can vouch for it. And this is what I do remember, rather than, no, that's what it shows. And I guess, I take what it shows over what I remember, which is more the feel of what happened in the set of questions, at least to me.
My review of the record, the way this presents, Your Honor, is so after she has gone through the version of events, she sees the inaccuracy between what she initially recalls in the video. The video itself has not been played in full for her. What follows is the prosecutor, there's some objections that take place, and then the prosecutor plays the full video for her to see. After she has seen it and essentially refreshed herself, so now she's seen the entirety of the video, that's when she's asked those buzzwords the second time. Is this a fair and accurate representation of what you recall seeing on June 12th? At that point, after she's stated what her recollection was, then she has seen the video in its entirety. That's when she's able to tell the court, yes, that is what I recall
So
seeing.
even after that, then the issue arose about all that, but I thought, I thought he had a gun, but I don't see it in there, so I'm not so sure about that. So there other obstacles arose thereafter.
I'm
Or am I-
sorry, I'm
am I
not sure. Like,
misrecollecting? I thought she then says, when kind of walking through what does the exhibit show thereafter. So, after it gets it, there's an effort, there's discussion of it, and then she says, yes, it fairly and accurately depicts, except like right away, except, I thought it was the elevator, but it's really the stairs or, but then there's round two where she's shown the whole thing and then she's asked without any real explanation, will you vouch for the whole thing? And she says, yes. But then after that, I thought issues arose about whether the video and her memory were consistent relative to whether Mr. Ransom had a gun or one could see a gun. Am I misrecollecting that? Or?
There is some later discussion regarding the gun and the fact that Mr. Ransom does not have a gun. And if what I recall in the record is she's explaining when asked a question that she thought he had a gun because she had been told that he had a gun. But my recollection of the record is that it's not specifically after the exhibit has been admitted that she still disagrees with it. I think
The last thing she says before the court overrules, again, defense counsel's objection and allows the video to be played is, I thought he came off the elevator. And so, I mean, the last thing she says undermines the very thing that's purporting to be authentication.
Yes, sir. And I mean that I can't. Those are the facts in the record. I think what is important is that after that statement, when she's able to see the entirety of the video, that's when she's able to provide an answer that yes, that is.
Well, at this point, she's sort of substantively testifying as she's watching the video and confirming that it depicts what it depicts. But that seems like it should logically come after the question of authentication. And if the video wasn't sufficiently authenticated, then that second step should have never happened in the first place, right?
I'm trying to make sure I'm understanding the question. So when she's shown the video initially, or at least a clip, there is this discussion that happens afterwards regarding some conflict between her memory and what she has observed. I do think it would be appropriate, though, prior, if there is some type of hiccup in authenticating, a video, or in this scenario, that you would ask the witness to view the entirety of the video, so that they could make a more accurate response to the question. If I'm going to answer, yes, this is a fair and accurate representation, but I've only seen a small portion of it.
Well, so let's say that's true. The state of affairs after that happened, you were adding some things that didn't actually happen on the record from the witness. So the state after the second effort, so it seems to me, was shown part of the exhibit, said yes, but no, because there's a difference between the exhibit and my memory. Effort number two, without any explanation by the witness, yes, it is consistent with my memory. So what the trial judge has in front of it is, once it's a no and once it's a yes with no explanation about which one is appropriate to give weight to. Why would it be appropriate to admit in those circumstances under any standard, whether it's a clear and convincing evidence standard, which would be really hard, or even a reasonable possibility standard? It seems like it's like witnesses said yes and no, and nobody's explained which answer is which.
Yes, sir. And I think that would go back to, at that point, the judge in this case and the witness were able to see the video in its entirety prior to that answer.
Well, that's a theory about how one could reconcile it. It has the difficulties that it's not supported by anything the witness said or by any inference or comment the trial court made. So what we're left with really is without any explanation, the witness says yes and no, and then the exhibit is admitted as authenticated. That seems difficult.
Yes, Your Honor, without, I guess, what followed, I mean, this, if there was, I guess, issues that followed, this would have been probably a good area for cross-examination or further, if there were concerns regarding the witness's second answer. At that point, there is nothing else in the record to suggest that is inaccurate or.
Nothing else other than the immediately preceding answer that was the
Yes, Your Honor.
And it's the government's burden, right? I mean, the proponent of the evidence has the burden to authenticate it.
We do, Your Honor. And when looking at the standard, which we believe this court has already addressed with Bryant and also in Thompson, that would be whether we have that reasonable possibility standard.
Can I ask you also, just wrapping around to after the yes, but no, and then yes without explanation about how it came from yes, but no to yes. There then is, it's on page 60 over to 61, when we're talking about the placement of the defendant's hands, and the witness is asked, is that what you remember when you testified earlier that you saw Mr. Ransom? And the answer is, I thought he had in his hand, but he didn't. That
Yes,
seems like the witness is saying, I mean, I guess you could say I used to remember that. That's what I used to remember, but now it's not what I remember, is how you would interpret that, because
Your
it
Honor,
sounds more naturally as, this is my memory was that he had it in his hand, but he didn't.
Yes, Your Honor. The way the government is interpreting that is it's a reference to when they initially discussed this, when she's telling the prosecutor up front that there's this conflict between my recollection and the video. That would be, again, it's referencing that when I initially saw this government exhibit 7, that is not the way that I remembered the small things from that video.
So what facts do you think she recalled that corroborate her authentication? So I mean, this is a very short clip, and the only two things that stand out to me is that he's coming off the stairs and he's holding a belt. The two things your witness says is he's coming off the elevator and he's holding a gun. So what did she say? And I remember those were the clothes he was wearing. That was what anything else?
No, Your Honor. I mean, it goes back to it's the correct time and location in which Mr. Ransom was fleeing the building.
How do we know that? Where's the timestamp? This could have been from any day, from any time. Maybe location. I can give you location. She might recognize, a fairly generic apartment complex hallway. It's got that bright green, so not so generic. But where are you getting time from?
The context in which the questions were asked. This wasn't the first question she's asked. This is during the course of her testimony. So she's already explained, that she encountered Miss Williams that night. That when she approached, she's.
I'm really confused. How do you know what night this video is taken from? How do we know that this isn't from 2 weeks earlier? What basis does she have to say that?
Because the evidence in the record, there weren't 2 nights that were discussed in which she saw Mr. Ransom fleeing the building.
But that begs the question. I mean, we know that they were in a relationship. He could have been in that building dozens of times, right? I mean, to say that this could only be the video of that night because he's in the video.
And Your Honor, that's not.
Flips the question on its head.
I think the facts surrounding, I mean, she says that she has seen this individual before, because he has been in the building before. But what she describes on that evening is a singular event. It is one time that she has been outside after her neighbor has, accused her boyfriend of domestic violence, and she's outside the building late at night, and she sees Mr. Ransom running.
I don't want to be a broken record, but why do you think? What basis does she have to think that Exhibit 7 of him running down the stairs with a belt in his hand? What basis does she have to say, and that's from the same night? Because the only two things she says that seem to be memorable to her about that night is that he's coming off the elevator and he's holding a gun, both of which are contradicted by the video.
Because I would say that there's a lot of Ms. Pryor's testimony where she misses some of the small things. I mean, she's very upfront, and the fact that she didn't have her glasses, she had been drinking at some amount.
So
But what she does remember are
what big thing does she get right about Exhibit 7? That he's going
the
down.
facts leading up to it, Your Honor, that at night she was approached by her neighbor who has just been assaulted by Mr. Ransom.
But that doesn't
Then she-
authenticate the facts leading up to whatever is depicted in the video. How does that authenticate what's in the video itself?
Your Honor, because it provides circumstantial evidence surrounding the context of the answer. If she were to just to provide
Can I
this,
ask you, does the back end of Exhibit 7 show the police or I thought it shows a little, what happens to the very back end of Exhibit 7? Do you recall? I don't have it.
Mr. Ransom essentially just moves out of the, he disappears from view, and that is the end of the video.
Some of these questions raise to my mind what your opponent is describing as kind of a second argument, which is whatever a careful explanation of the reasons for authentication might have been able to allow, there wasn't one here. And so, it might have been a different case if some of the arguments that you're making now about, well, the circumstantial evidence could, and I actually think that the second time through, the witness saw the full thing, and I'm going to infer that the witness has now got a refreshed recollection and is authenticating the video rather than kind of capitulating to what's depicted in it as superior to her recollection. It might have been different if the trial court made and gave explanations like that, but the trial court didn't do any of that. And your opponent's argument is that in itself precludes us from affirming, because we can't really affirm an exercise of discretion that isn't adequately explained. What's your response to that line of thought?
You ought to take that in two parts. So to start with, we do have an understanding of the trial court's position on these videos. Prior to the trial beginning, there is a discussion. Basically, I have an objection to the government exhibits, which are going to be 1 through 7 at the time. And it's stated because there are no timestamps, no date stamps, the government will not be able to authenticate these. At that time, the court tells defense counsel essentially that those do not need time or date stamps. That's going to go towards weight, not the admissibility. So we do have an understanding at that point of what the court is looking at the standard for
At
authentication.
that level of generality, that it's fair enough to say under our case law that there's no flat requirement that there be date or timestamps. If that's the trial court's point, that's fine as far as it goes, but that doesn't really tell you about whether the alternative way of trying to authenticate it that spun out in the trial was adequate or not, and why the trial court thought it would be adequate. So I for sure, the trial court adequately explained why the trial court and correctly, as a matter of law, explained that there's no flat requirement here that you take this video depiction and you have date stamps or chain of custody or that. There are other ways of getting that done. That's true. I take that, but I'm not sure how it helps address the question of whether that alternate route was adequately achieved here.
Your Honor, and I guess kind of building on that, there's an understanding that the trial judge is assumed to know the law. So when they're having a discussion, there's an objection for lack of authentication.
But that's a fair point too, but it isn't, is it law? The argument, for example, that the right way of understanding this is that the witness, and with respect to Exhibit 7, the witness is asked a question about, I've shown you part of this video, can you vouch for it? I'm paraphrasing, obviously. And the witness says yes, but no. That seems like a problem left unaddressed. But then there's let's play the whole video, and the whole video is played, and the witness says yes. The right way of looking at that, you're saying, is, or at least one way that a reasonable gatekeeper could look at it would be to say, well, I'm not going to say that's a witness who's saying yes and no, I'm not going to let it in. I'm going to say that the second time through, the way I'm going to interpret that is that the witness had a full chance and the witness is now vouching for it fully. None of that's law. That's like what inferences you draw as a reasonable gatekeeper about how to understand what seems like some challenging testimony about whether, or challenging evidence about whether to admit an exhibit.
Your Honor, it would be much easier if the record was developed more fully on the judge's thought process. That would be great to have that in the record. What I would say is that if you look at just the overall arc of the of the proceeding. You have the judge laying out basically the judge's understanding of what the law is. And then at each objection, you have the facts surrounding the objection, and then the judge ultimately ruling. I do think by there being the repeated same objection, which again, it's authentication, lack of date and timestamps. It's not as encompassing as the brief and the discussion that we're necessarily having here.
It's not just date and timestamps. I mean, I'm looking at page 19. There's no date and no date stamp on this, no timestamp, no evidence that this was filmed on the exact date that we're talking about. There's no evidence of any sort.
Yes, Your Honor. When you look at the testimony of Ms. Williams and then Ms. Pryor, prior to each exhibit being offered, they're having a discussion about the facts of that evening, which have been established that it happened on June 11th going into June 12th, but they're talking about a specific evening. When they see that video, and especially with, like, for instance, the first video, it is offered and do you recognize anyone in this footage? They have watched this and they are able to say that, yes, that is a fair and accurate representation of that day. At that point, I mean, I'm sorry.
There was no testimony that was a fair and accurate representation of, I'm not sure what you mean by that date. There was a representation that it was a fair and accurate depiction of the hallway. And then there was testimony on that, and then there was testimony that on that date, and then there was testimony. For sure, I get you on the date, but there was not testimony. I mean, she testified she recognized herself and her daughter in it. And she concluded, I guess, that she indicated she believed it was the same day in question because she had worn those clothes on that date. I tend to think that under a reasonable probability standard, you'd be fine there. Whether clear and convincing evidence might be a little tougher slog because, I mean, people wear clothes more than one time. And so it is it's certainly not by any means a certainty that that any particular, and who knows how often she walked in the back door with her daughter, but it's not like she says, yes, and that's, that is us walking in that day. And I know that because I remember I was I was holding her right hand and we were walking up, and it's also the clothes, and I can vouch for, that's what I did on that date, and it's accurately depicted there. She didn't get all the way to that.
Yes, sir. And the reason I brought up date is when the prosecutor asked the fair and accurate representation, while it does not have event depicted in 1 through 5, she does include the date. So the answers that follow from the witness are specifically for that date. If there was an issue with that date, or we had reason to believe that that is inaccurate, that those questions could have been addressed on cross-examination. The defense counsel could have, raise those in the objections themselves, but they do say that they happened on that date.
Can I ask you, I guess there are two topics I'm interested in discussing, I haven't gotten to yet. I know your time is up, but the first of them is just the standards that we should be applying. And I know the United States is taking the position that that really is answered by Johnson, and that the picture you're painting is kind of like Johnson says, audio tapes are their own little island, and we're not expanding audio tapes to social media. And so why would you expand to video depictions? They're not meaningfully different from social media, which is a perfectly good line of thinking. But I guess I have a couple questions about it as far as it goes. One of them is do you think there's a logical reason to distinguish between audio recordings on the one hand and social media evidence and video depictions on the other? Is there some logical distinction, a logical basis?
Your Honor, there's a good line from Johnson when it is talking about the voice recordings, and it's specifically with the voice recordings. It talks about that the sound recordings, more so than other demonstrative evidence, are more susceptible to alterations that could be impossible to detect. I do think the sound recordings just inherently, especially if they're talking about, relevant facts, whether they're probative or prejudicial, are going to have an immense impact on the fact finder. And what we're dealing with here, we were talking about the limited relevance of these videos that are essentially offered as corroboration of portions of Miss Williams' testimony, as in where they went and the manner in which they went there. I do think those are very.
I'm no expert in any of this, but off the top of my head, I would think that it is equally possible to manipulate video evidence as to manipulate audio evidence in a way that people wouldn't depict. So it doesn't, that distinction doesn't really so much off the top of my head seem like that plausible one. What would be the basis for thinking that actually it's harder to get away with manipulating audio evidence than video evidence?
Well, Your Honor, with video evidence, I mean, I guess there's two ways in which this could be authenticated. One could be the route in which the appellant is suggesting that we have all of the background and the chain of custody and the creator of the video. That's one. But in this case, the other way is to have someone that was present during the video speak to it, and which is what the government presented here.
Yes, but I mean, maybe this is just my own lack of capability in certain respects, but if I walked through an apartment building hallway and things happened, and then somebody later showed me a video of it, and it actually was a video of it, but the way it was going to be authenticated was somebody's going to say to me, does that accurately depict what happened? And is that an accurate depiction of the area where it happened? I mean, there's an actual video depiction of that is going to have tons of information that's going to run way beyond what I would have remembered for sure. And I mean, a good defense attorney, if it had really mattered, I think probably could have had fun with these witnesses by saying, okay, you're vouching for, this is a fair and accurate depiction of the hallway. Here, let's take the video down. How many were you holding your child's left hand or your right hand? If you're talking about actions there, or like how many tiles were on the floor of the hallway. And there's tons of video information in there that no witness is going to be able to recall, and that could easily be manipulated. Now, if it gets to be the critical issues, then maybe, and if the witness is authenticating, say, yeah, I specifically remember that. But I just think there's plenty of opportunity for both to, in theory, manipulate things.
I guess I would highlight the hypothetical you've presented with, there's this essentially cross-examination aspect of it. That if a witness is going to authenticate it, then I think that the opposing counsel has the opportunity to.
I get that, but my question really is, I mean, I 100% get that point, but it seems to me that's equal in audio evidence and in video evidence, and the ability to manipulate is equal with both, as far as I could tell off the top of my head. And so I don't really see a rational basis for distinguishing between video depictions, videotapes, or social media evidence on the one hand. I mean, maybe social media evidence is a little bit different, because you were saying, or your opponent was saying, that it might be harder to get access to it to manipulate it. That may be true. I don't know. I can't vouch for that for sure. But video evidence, just like, I come in with a video depiction. I'm not saying where I got it. For all I know, like it was a reconstruction that was never actually recorded by anything, but I've just sort of used AI to create it. We don't know as a matter of evidence in this case that isn't what happened here. We just don't know. I just don't see any distinction between the risks of manipulation, or the likelihood that cross-ex would be more effective in revealing manipulation if it occurred in one category or the other. So it seems somewhat arbitrary to limit the clear and convincing evidence standard, which, I have my own doubts about whether that was an appropriate standard to impose initially, but it seems pretty artificial or arbitrary to limit it to audio depictions.
Your Honor, and when I hear that, I guess I go back to the facts of Butler, because in Butler, there was no witness to the conversation to authenticate it. Essentially, the co-defendant were not a part of any testimony that would be presented at trial to authenticate that.
Yeah, and it seems to me that answer, it has the same abstract analytical complication that your opponent's answer did, which is, it seems to suggest that which standard is going to apply is going to depend on the case-specific circumstances of how strong the case for authentication is.
And you're right, I guess, with the idea of expanding that clear and convincing standard, I guess I would say that that is a complex question, given the way that technology is evolving and the law is chasing it. With this case specifically, the United States would say is not the correct vehicle for that. Because we do have two individuals that testified in the case. And also this issue wasn't raised at the trial court level. So there's no litigation, there's no evidence essentially on the record regarding the outside of the testimonies of the government witnesses. There's nothing on the record that would go into, what is an AI deep fake or anything.
It doesn't, counsel, it doesn't need to be a deep fake. I mean, Miss Williams could have walked this hallway with her daughter the day after the assault. She could have done it the day before trial. I mean, the only thing that clips 1 through 5 show are her walking down the hallway, coming up the back stairs, running down the hallway, running out the front door. She could have made that video 1 hour before trial without any problem, right? You don't need to get imaginative with like AI deepfakes. It's, let me walk through my apartment hallway and set up some cameras, or ask the super to give me the video of this day because I was interested in something. It's not hard to imagine.
Yes, sir. It goes back to in this case, there are witnesses that testified, which we're looking at, where that standard should be, and if it should be expand beyond that limited exception with, audio recording voice conversations. In this case, we have witnesses that testified that on this date, they were in these locations. They remembered their actions leading up to the videos. They remembered their appearance. They remembered who they were with. They were able to provide evidence to essentially assist with the authentication of the videos. And
Second of the two topics I wanted to make sure we get to is, I know that you have argued in your brief that any error here was harmless, and focusing in particular on Exhibit 7,
Yes,
which seems like the hardest harmless error argument for you to make if it was erroneously admitted. I mean, the trial court, in finding guilt with respect to the assault on the child, said pretty much like one concrete thing, and it was, I'm paraphrasing, but I notice it's important to me that the defendant is holding his belt on the way out.
yes,
Holding his belt or his waist, something like that, which seems clearly to be relying on the video and on an aspect of the video that seems particularly debatable, that the witness was able to specifically authenticate the video. So why would that not be harmful relative, at least to the assault on the conviction for the assault on the child?
Your Honor, to start with, we argued in the sufficiency section of the brief that the case itself stood on its own. So you have the testimony which was credited of Miss Williams that she was punched in the face multiple times. There were injuries that from Government's Exhibit 8 and 9 that corroborated that fact. She also said that she observed the MWB struck with the belt. Those statements were credited. And then you have Government Exhibit 10, which is this outcry to police. So if you just take that portion of the case, I think the case stands on its own with regards to the 2 assault convictions. With Government Exhibit 7 specifically.
Stand on its own isn't really an established harmless error test. So you're right, the evidence is sufficient,
yes,
for sure. The question is, I guess, whether there is.
Yes, Your Honor. And so that kind of rolls into this harmless error discussion. So you have this case that is standing on its own without the admission of Government Exhibit 7. If Government Exhibit 7 had not been presented to the court, what we would have had is Ms. Pryor testifying that she saw him run out holding a gun. So I think at that point, the facts would, they would be different before the court. But they would, we argued in the brief, potentially the omission of the evidence assisted the defense in.
Well, that's a separate count. I mean, how can you possibly say that the fact that the evidence supported the defense theory on a completely separate count made it harmless as to count B?
Because the manner in which it corroborated the testimony of Ms. Williams. So with Government Exhibit 7, I think if anything, we've got credited the testimony of Ms. Williams, seeing Government Exhibit 7, while it did not, the judge still found Ms. Williams credible.
I mean, not entirely. She acquitted on the gun charge.
Yes, Your Honor. What I'm saying is Government Exhibit 7 provided, I guess, the court a a better reflection of the facts of the case, if that makes sense.
Right,
That's
That's on the
exactly.
assumption that it
And
was,
so-
if it was properly admitted, if it was improperly admitted, erroneously admitted, then it seems like what the trial court did was rely on that depiction for something that was very murky from the witness's testimony and say that's important to me in finding the defendant guilty of the assault on the child.
Yes, Your Honor. But I also think with the credited testimony of Ms. Williams, with regards to the assault within the apartment. If there was error in admitting the video, I don't think it would rise to the level to.
But when
essentially
we know,
change
when the trier of fact essentially tells us what it found most dispositive or helpful, how can we ignore that on a harmlessness, harmfulness question?
If the court did find that, the video was not properly authenticated and I do think that is the question for the court is to resolve whether or not it was harmless. The government is asking is that in the finding of fact, while it is referenced, that is not the reason for the conviction. She does not state that because of this video, I have found, the assault on MW. That is not the basis for the conviction. That was a factor that she did specify. You also have the testimony of Ms. Williams, who she credited to a large extent, along with a corroboration of what took place before and after, as well as video evidence from Government Exhibit 10. There's additional evidence to add in that would, remove any concern regarding any error caused by the admission of Government Exhibit 7. And, unless there are further questions, the United States asks that the convictions of the Superior Court be affirmed with respect to both assault counts.
Thank you, counsel.
And I think I would like to start with your point, Judge McLeese, that what is the logical distinction between voice recordings and any other media at this point, video or photographs? And there is no longer any logical distinction. The impossible to detect alteration language that is quoted in Johnson comes from Butler, I believe. And in Butler is a 1994 case. And in 1994, it was much easier to manipulate audio. It required less equipment than it was to do something with video or photographs or to make that convincing. I think that required an entire Hollywood studio in 1994. And now you can pretty much do it on any computer with internet access and create something of probably better results than you could possibly have gotten in 1994. So I think it's this war between resources, but now,
Although, as Judge Steele's question earlier pointed out, that reflects only one way in which you can present video evidence or audio evidence in a way that isn't actually fair and truthful. I mean, you can have reenactments, so you could create a new tape, an audio tape, and just have someone speak some words, and then someone would say, yeah, that was what I heard on the day in question, even though the tape was created some different time. And the same would be true of video. You could have just do a little reenactment and present it as though it was something recorded on the day of. That could have been done, back in the 80s and still could be done now without any kind of fancy technology.
yes, a reenactment. I guess in your scenario, you're not disclosing to the actual trial fact that it's a reenactment.
No, I mean, theoretically, it's a funny feature of this idea that you can go ahead and get a video exhibit in only through someone who will say, yeah, that looks like what I remember. I mean, theoretically, you could create, you could say, if you had a witness who told a story and you thought, wow, it'd be really great to show that to the jury visually. So here's what I'm going to do. I'm going to have the witness, reenact it. And I'm going to video it, and then I'm not going to, I'm not going to say what it is. I'm not going to call it anything other than a visual depiction. And I'm going to introduce it through the witness, and the witnesses will say, yeah, that's exactly what I remember. And it would come in, and the fact finder wouldn't even know that it was, you could have angles. So it looks like it's a surveillance camera, but it really isn't. Or it is a surveillance camera. It wasn't even a surveillance camera, it just has the angles. It looks like it. Theoretically, you could do that. That's a funny feature of I mean, I say theoretically, if you were the government doing it in a criminal case, there might be Brady issues about not disclosing what you're doing for sure. But as far as authentication goes, it's not clear there's any obstacle to doing that.
And I think actually that raises a very important point, that the chain of custody has to be important, because the chain of custody is how you solve that problem. If the government had brought in a police officer or somebody who actually retrieved the video from, and let's say it is a surveillance system, and they retrieved from the surveillance system, they said, yeah, I pulled those videos on the night of this incident. I checked the timestamps on the video surveillance system. Here are the checksums for the videos that I pulled. These are the same checksums of the videos in the court. No problem. Now you've got.
Yeah, I get that line of thought, but the problem there, I think we have controlling authority that says otherwise. And the federal rules of authentication, which we have not adopted, they also seem to permit this. But we have cases which will say you can get in a depiction, audio or video, by just having a witness vouch for it without having any information about how it was made. So that, whatever one might think of that as an original matter, I think that's water under the bridge for us.
But I think that maybe that's where Butler comes in, is where you have this issue with the chain of custody, where there's nothing there and you have some issue, either a witness saying yes and no in a confusing way, or a less than convincing testimony about authenticating it in the first place. So you can sort of bolster the authentication of something by showing more with the chain of custody.
I still think that's just a matter of meeting the standard or not meeting the standard, as opposed to what standard applies, which I think I tend to agree with Judge McLeese that Butler probably just respectfully got it wrong by elevating the standard instead of simply saying that because there was no way to know whether that audio had been manipulated, that and there were no other, indicia of authentication, that it just simply hadn't met the reasonable probability standard. It probably would have been the better way to go in Butler, but we're not there.
And there are cases that do require at least something in the chain of custody. And I don't know, this goes back to whether or not, are we going to call this sort of physical evidence? Was this a CD that was brought in, or is this some piece of physical evidence? Or do we treat it more like something else? But it is difficult, but I do think that one of the possible solutions here is that we do require something as far as the chain of custody. And we would argue that Butler was good law. I think that it raises a valid issue, and where there is this fundamental opportunity for adulteration. And that's what it is. It's this opportunity for adulteration because it hasn't been explained where the video came from. And when you have a witness saying both yes and no to important points, that does raise the specter that maybe there has been something changed about this video. So I think that's one possible solution, is looking at this and saying, well, that's adulteration. And our other arguments as far as exhibits 1 through 5 would be that there is definite evidence of alteration in just the fact that it's the 10-second clips. So presumably there had to be a hole. And this is what distinguishes this case from Johnson, was that in Johnson, the entirety of the video was admitted, and the issue was about this edited clip. So they basically put a best of clips in as well. And the complaint in Johnson.
I do struggle with the idea that selectivity or lack of completeness is a form of alteration that triggers special concerns. I mean, there's a rule of completeness that is a way of, for any party who thinks, who knows what all of anything is anyway, but like somebody puts in some evidence and the issue, is part of a conversation, and that what all needs to be considered part of the same conversation, that's sometimes blurry. But if you're a party and you think, well, there's been some selectivity, then the rule of completeness is a perfectly good solution to that. I don't know that selectivity or lack of completeness is, you have case law that says that it is a form of alteration triggering special concern for purposes of authenticity, that what is being admitted is only a portion of a thing rather than what you might think of as a complete version of that thing?
One of the cases that I cited in my footnote was not a case from this jurisdiction, but it dealt with, or it only permitted the introduction of a recording with gaps in it. because there was a custodian of record who came in and testified that those gaps were caused because the actual equipment only recorded when there was sound. And so when you had the absence of sound, the recording equipment shut off. And so they were able to explain those gaps. I believe it was out of Illinois' silent witness theory, and it's one of my footnotes in my opening brief. And so that case does deal with it and require some explanation of the recording equipment.
Yeah, it seems potentially different. If someone is showing what doesn't seem to be inexplicably interrupted stretch, but it's obviously not everything. I mean, it's limited in time as anything that you're gonna introduce into evidence will be. It seems to me that the concerns there are sufficiently different that I'm not sure that's gonna provide a lot of support for the idea that just the fact that what is being introduced is a temporally limited piece of video footage is itself a form of alteration.
I would say that there is no explanation for why the clips stop at this point or why each clip is
No,
exactly 10
just a
seconds.
hypothetical. Imagine that, in a nightmarish scenario, I'm a trial attorney and I am trying to introduce a video depiction. And it's 10 seconds long and my opponent says, well, that's been altered. So we need to have special rules about all of this. It just seems it's temporarily limited as anything would be. Why would I? And then I know there were multiple here, but each one is its own and each one is temporarily limited. And if somebody, it just doesn't seem like that it's temporally limited is a form of alteration.
I think what's fundamentally different in this case is that, and as it's said during the pretrial or conference before they actually start the trial, is these clips were turned over rather late. I think the defense attorney says they were turned over the night before. And all that is turned over is the clips. There isn't a whole video there. The defense attorney can't go and say, hey, rule of completeness, play the next 10 clips or get up and play the additional clips. All that was given to the defense were the 10-second clips.
I mean, that seems like a potential objection that could have been raised in the trial court and developed here, but none of that was. I'm not sure how that's going to affect the disposition of this appeal.
And I guess with that, if there's no further questions, I would ask the court to reverse each of Mr. Ransom's convictions.
We will thank you, counsel, for your briefs and your arguments today, and the case will be submitted.
Thank you.
All rise. Honorable court is now adjourned.